Okay, good morning on this wet Sydney morning. Everybody who's here, their feet look dry, which is a good thing. I hope you're all ready for an exciting day of interesting presentations and discussions. My name is Stacey Strong. I'm an associate professor here at the Sydney Law School, and I'm co-director of the Sydney Centre for International Law. Thank you, Andy. I'm co-director along with Professor Emily Crawford, who's going to be chairing the first panel of the day. I now want to briefly introduce, because he needs no real introduction, Dean Simon Bronick.
Well, thank you, Michael, for that welcome. I think today, like many people, may not have got much sleep last night, or if it was a bit broken watching what's happening over the world. And I think your message of the importance of acknowledging the importance of sitting down and yarning about disputes, and of course First Nations people do that, and even from your speech, the importance of that respectful engagement with people from other places when they enter onto your country probably is more potent today than it would be ordinarily. I'm delighted to welcome you here to the SIL Centre for International Law at Sydney International Law in Review on a day which is probably going to be known in history as I hope not, but another European war of great significance, and obviously acknowledging what's happening there will probably be a theme that will run through many of the conversations around the coffee and the and undoubtedly on the chat online. So acknowledging First Nations, incredibly important, acknowledging the fragility of the world upon which we live. One thing you learn from First Law, the law of First Nations people, is it is all connected. Our planetary health, the state of relations between different nations and nations within nations is so incredibly important. We have lots to learn by listening to other ways of resolving dispute. And it's better to do it with words and in courts rather than on the battlefields. And I thought we would have learned that lesson. And I'm so deeply perturbed, particularly as we know it's the civilian communities that will really pay the ultimate price. And it is terrible what's happening. Our law school has a long history of international law that dates right back to the foundation dean, Pitt Cobbett, in 1890. He was one of the leading scholars of the law of nations, as it was, and private international law, conflicts of law. He actually embedded it in the curriculum. So unlike most law schools of his time, it was teaching courses with an international and global reach. He's often also known for his work on the Constitution, but so much of the DNA of that foundation dean remain in our law school, where private international law and public international law are both compulsory subjects. So it's no surprise that we have a centre like SIL, and I thank Stacey and Mary and Rose Gray, who made an outstanding appearance recently, giving expert evidence before the International Criminal Court. Our knowledge of international law is not just academic, that tendency always to think that we're just scribbling away on things of high theory, and when you see our colleagues actually standing up and influencing the doctrine and the way in which international law develops, it's an amazing thing to watch. And I encourage you to watch that on our social media feeds, where there's some reporting of that contribution. So look, as a dean, I'm always running from one event to another, and it is still our first week of teaching, so there's still many things, and we even have other UN-related events going on later, with Michael Kirby coming to speak. So we've got a pretty full agenda today in the law school. I'd like to say it's just another day in the law school, but it's not, because over the last 18 months, we've been very limited in our ability to welcome people onto our campus. And so for that reason, I'm particularly delighted to welcome you to this event and to the New Law Building, and also not to forget the 70 people almost that are online, no doubt zooming in from not only all parts of Australia, but also across borders. And look, I wish you all the best for your day. I'll be popping in and out as best I can, but you've got a great agenda. And the first keynote with Tila Reid introducing Megan Davis. And I should say that we're very proud at our law school that we have endorsed and are a supporter of the Uluru Statement. And I really commend the work that's been done by Megan, Auntie Pat and Noel Pearson in driving the Uluru Statement. And we're very proud as a law school to have endorsed that last year. So with that, I'll hand back to Stacey. Thank you.
Thank you. And the speakers can never see me smiling at them as I come up because I'm busy ripping off my mask. So I get the exciting part of the logistical discussion here. So first, this conference is attracting CPD points. Simran Singh, who has been in great communication with all of you, will send an email to all registrants post-conference with that information. If you haven't guessed, I do speak very quickly. If I say anything that you don't understand, please raise a hand if you're in the room or squawk on chat. But I will not be speaking much today for various reasons, one of which I talk too fast. The conference is being recorded, and registrants will receive an email, again, from our fantastic Simran Singh, once the replay is available on the podcast page. I do need to announce a change in the schedule. Unfortunately, our literary lunch speaker, Tara June Winch, had unavoidable personal issues arise, so the literary lunch will be going forward, but our own fantastic Emily Crawford is going to be speaking about her book, Non-Binding Norms in International Humanitarian Law, which is also the subject of our book launch later, but she is going to get into in more depth with a discussion with our very own Dr. Rosemary Gray. We're going to ask that our speakers keep to time. Another reason I speak very quickly, but I do want to extend some thanks. First, of course, to Simon for his support as Dean, to Michael for making it all this way in the pouring rain. Thanks to Simran Singh and Andy Netherington for their fantastic logistical assistance. Thanks to the interns, many of whom are here today, and they have been assisting Mary Crock and myself with creating the articles that will be published in the Australian Yearbook of International Law on current developments over the last year or so. I want to acknowledge OGMID as a media co-sponsor, and I want to acknowledge our speakers and moderators generally. Even though I'm speaking very quickly, my thanks is indeed heartfelt. I do now want to segue to the important stuff, which is our keynote speaker. As Simon mentioned, the session is going to be chaired by our very own Tila Reid. Tila is a proud Wiradjuri and Waliwan woman, and I do apologize for the pronunciation. I did not have a chance to check it with her ahead of time, so my apologies to the nations in general. Tila is a lawyer, a storyteller, and a co-founder of Black Fola Book Club, which is a platform that honors First Nations ancestors as the original storytellers. Tila is a Sydney-based solicitor practicing in Aboriginal land rights litigation and is, as Simon said, our current practitioner in residence here at Sydney Law School. She is also a campaigner for the Uluru Statement from the Heart and was a working group leader on Section 5126. Had to do my Roman numerals there more quickly than I should have, as well as the race power at the Sydney Constitutional Dialogue. I believe that Tila is online, so I'm going to hand it over to you. For those in the room, during the question and answer period, we will be taking questions with the microphones. Tila will let us know when that time is, but Tila, please, over to you.
Yama, everyone. Thank you for the introduction. I'd just like to acknowledge that the country we live and work on always was and always will be Aboriginal land. Thank you, Michael, for your acknowledgement of country and Metro Lands Council as the local cultural authority. Also to Simon Bronnett for your acknowledgement that all of these laws are interconnected. I have the absolute privilege today of introducing a very dear person, very close to my heart, Professor Megan Davis, just remember that at the end of this, we're going to have about a 15-minute Q&A. So please put your questions in the chat, and I will field them out towards the end of Professor Davis's keynote. Professor Megan Davis is a Professor of Constitutional Law and holds the Balnaves Chair in Constitutional Law and is Pro-Vice-Chancellor Indigenous at UNSW Sydney. Professor Davis is an Acting Commissioner of the New South Wales Land and Environment Court. Professor Davis was a member of the Prime Minister's Referendum Council and the Prime Minister's Expert Panel on the recognition of Aboriginal and Torres Strait Islander peoples in the Constitution. Professor Davis is a globally recognised expert on Indigenous peoples' rights. Megan was an expert member of the United Nations Permanent Forum on Indigenous Issues from 2011 to 2016, and is currently an expert member and chair of the United Nations Human Rights Council Expert Mechanism on the Rights of Indigenous Peoples from 2017 to 2022. In 2022, Professor Megan Davis will be a co-recipient of the Sydney Peace Prize for the Uluru Statement from the Heart. So Professor Davis, thank you for joining us today, and it's over to you.
Thank you, Taylor, and thank you for that introduction. It's a bit weird when you introduce me because we've known each other for so long. In any event, thanks for that acknowledgement as well. I'm ringing in from Yugambeh country, which is south of, I'm trying to get my bearings right, south of Brisbane. And we've lived here, or at least my mum has lived here in this little housing commission house here in Logan for 34 years. So we've been living on Yugambeh country for that long. So it's nice to be back in Brisbane. In the time available, and I'll try and stick to the time, I have prepared a paper on the Uluru Statement from the Heart and Public International Law, and I think I'll try and truncate it a little bit so that we can get some question time in. What I wanted to talk about, I suppose, is something obviously very topical because we're, 5 years post the Uluru Statement from the Heart, and from us issuing the Uluru Statement from the Heart to the Australian people, and we face an election very soon in which one party has committed to a first-term referendum on a constitutionally enshrined voice to Parliament, and the other party hasn't, and from what we can tell, has abandoned that framework and has abandoned the 12 years of bipartisanship on constitutional recognition. Australia's not had a successful referendum for 45 years, and the last failed referendum was the one that Taylor and I speak about a lot, was 23 years ago, the Republic referendum. So I wanted to speak a bit about the influence that public international law did have on the thinking, the process, the substantive elements of the Uluru Statement from the Heart. And as I said, I'll try and truncate it now to about 20 minutes to give Taylor enough time for questions. Really what I wanted to touch upon was to speak to, as I said, the importance of the DRIP in framing this work. And in particular, the voice to Parliament is very much anchored in the Declaration's Articles 18 and 19, political rights, and the Uluru Statement from the Heart, or at least the first aspect of that reform agenda, does call for greater political participation in the democratic framework of the state, which is what the Declaration on the Right, the Declaration on the Rights of Indigenous Peoples does set up. It sets up a dynamic in terms of self-determination that enables Indigenous peoples to engage with the state in the way that they see fit, in addition to being able to set up, and the state being able to provide the resources and the environment in which they can set up their own autonomous functions. And so there's two kind of very different conceptual elements to the right to self-determination. And this one very much speaks to Indigenous peoples wanting an enhanced mechanism to enhance their participation in the democratic life of the state. So I want to speak a little bit to that, and then I just want to touch upon how the guiding principles were developed for the Uluru Statement from the Heart. These guiding principles were developed to determine and assess proposals for constitutional recognition that came to First Nations peoples, and that would influence the decision making both out at the Rock with Uluru, but afterwards in terms of negotiating with the state. And then I just will end by talking to a few comments about self-determination, actually. I wish I could go to the last part first because it's much more, not controversial, but I want to talk about the ways in which the Australian state since 2014 is trying to recalibrate what the meaning of the right to self-determination is. And it's a little bit consistent with the way the right to self-determination is being reinterpreted across the world in the area of Indigenous peoples, where self-determination means less about collective rights and more about what the state thinks self-determination is at any one point in time. And in Australia, we talk a lot about the states wanting Indigenous peoples to incorporate, and incorporation is the mechanism and the vehicle for self-determination. But I also want to talk about the way in which the Commonwealth talks to entrepreneurialism and capitalism and Indigenous small business and procurement as being the key elements of the Uluru Statement from the Heart. Of the Declaration on the Rights of Indigenous Peoples and Article 3. So to begin with, just to touch upon, I mean, most people know this, that the declaration is a non-binding declaration of the General Assembly. It's regarded as soft international law and that it does not create any binding legal obligations in domestic legal systems, but we also know that's entirely contingent on the domestic legal system. Declarations can be used in various ways across the many legal systems that do exist, and in particular it can be used in the context of statutory ambiguity, and there's multiple rules that have come into play as I've seen the DRIP be implemented across the world as to whether it is binding or not binding. I find the binding not binding debate a little bit dull because you find students, when I teach public international law and Indigenous peoples in international law, dismiss the declaration on the basis that it's soft law and has no impact in domestic law and therefore it's not important. It has been a really critical declaration in terms of the elaboration and recognition of Indigenous peoples' rights, and you can see the way that is influencing many different legal systems across the world. We track the way in which it is being implemented into legislation, for example. It's only been recognised in a couple of constitutions, but it is being implemented in domestic legal systems via legislation, such as the most recent legislation passed in Canada, which implements the entire UN Declaration into statute. The declaration is important because it is a international kind of affirmation of this corpus of Indigenous rights norms that really take existing international human rights norms, but applies them to the collective. So really, there are no new legal rights contained in the declaration, but what they do is they take them, the kind of individual notion of international human rights law, and applies those rights to the collective. And that is substantially what is at the heart of the Declaration on the Rights of Indigenous Peoples. And I should put in a plug for our new UNDRIP OSLI database, where we're tracking domestic and international jurisprudence so that we can track the implementation of the Declaration's use globally. So, as I said from the outset, Article 18 and 19 really anchored a lot of the work of the Uluru Statement, and that focused not so much around what people thought the Uluru Statement would do, and that is propose a treaty, but rather people were interested in the ways in which we could develop a mechanism that enhanced their political rights and enabled them to participate in the kinds of decisions that affect their conditions and the material and political support that allows our communities to flourish. And so it's not surprised that the Declaration was used as the yardstick in the work that we did. As many of you know, the rights in the Declaration, when broken down, are clustered in a number of ways that enable Indigenous peoples to use it as a kind of tactile tool in their negotiations and discussions with government or among themselves on rights. And it's clustered in a number of things: the right to self-determination, life, integrity and security, cultural, spiritual and linguistic identity, education, information and labour rights, participatory development and economic and social rights, and then the land and resource rights, which were the most controversial in their drafting, but are substantive rights relating to lands, territories and resources. And finally, the back end of the Declaration, which sets up the exercise of self-determination and the kinds of things that the state should recognise and should provide in order to allow the Declaration to be properly implemented, to allow self-determination to be properly implemented in domestic, legal and political systems. And so the back end of the Declaration speaks to, Article 37, for example, speaks to treaties, agreements and constructive arrangements with states. Article 38 talks about the legislative measures that need to be taken to achieve the ends of the DRIP, of the Declaration on the Rights of Indigenous Peoples. Article 39 talks to the financial and technical assistance from states for the enjoyment of the rights that are contained in the DRIP. And so that the DRIP actually does contain a lot of information about what domestic implementation looks like and how that should be done. I've referred to Article 18 and 19, but I haven't read out what they say. Article 18 of the Declaration recognises the right of Indigenous peoples to participate in decision-making in matters that affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions. Article 19 requires states to consult and cooperate in good faith with Indigenous peoples concerned through representative institutions before adopting legislative or administrative measures that affect them. So Article 18 and 19, as I said, were really key influences and shaped a lot of the conversations about the reforms that were agreed to by Turnbull and Shorten, and that came out to communities where they deliberated in a process known as the constitutional dialogue. Just moving on and conscious of time, I just wanted to set out that kind of background of DRIP in Article 18 and 19 and just talk a little bit more, as I said from the outset, about the guiding principles. The guiding principles can be found in the document that is the Uluru Statement from the Heart, which is about 18 pages. And it has the front page, which is the logic that was issued to the Australian people by way of an invitation about why the reforms were necessary. And then there's a very lengthy part of the Uluru Statement called Our Story. And Our Story is the Aboriginal version of Australian history. I'm just going to turn my aircon on because it's really hot up. It's very hot up here in Queensland. It's very humid. And now I've just lost my train of thought. I shouldn't have turned the aircon on. So the guiding principles were effectively utilised just to run a ruler across those options that were brought out to the constitutional dialogue. And these were very heavily imbued with the Declaration and international law around Indigenous people's rights. So it comes as no surprise to anyone, given the active role that Aboriginal and Torres Strait Islander people in Australia have played for 4 decades in the UN system and in the articulation and elaboration of Indigenous people's rights. Many of the people who participated in the grassroots dialogues were people that had spent at least one meeting in Geneva contributing to the drafting of the Declaration, either by way of the UN Working Group on Indigenous Populations or by way of the intercessional group set up by the Commission on Human Rights to elaborate the draft Declaration on the Rights of Indigenous Peoples. So there was a very high literacy among the community about the international system, about public international law and Indigenous people's rights. So I'll just run through a few of those principles and identify those kind of elements of the DRIP, because I think it's quite interesting to see the things that draw from public international law that did influence the decision making or the assessment of the reform proposals that came out to us and were finalised at the Uluru Convention. But the 10 principles are that, you know, for any reform proposal to proceed, for us to agree to and proceed in terms of negotiations, the first is that it should not diminish Aboriginal sovereignty and Torres Strait Islander sovereignty. The second principle is that it should involve substantive structural reform. The third is that it should advance self-determination and the standards established under the UN Declaration on the Rights of Indigenous Peoples. The fourth is that it should recognise the status and rights of First Nations. The fifth is that it should tell the truth of history. The sixth is that it should not foreclose on future advancements. The seventh is that it must not waste the opportunity of reform. The eighth is that the proposal should provide a mechanism for First Nations agreement making. The ninth, which is very important because this is key, it should have the support of First Nations. And the 10th principle is that it should not interfere with positive legal arrangements. So just to go through, just to pick out a couple of those principles, not all, to just explain how international law, public international law, the DRIP, influence those principles. I think principle 2 is interesting, that it involves, it must involve substantive and structural reform. Now, this is something that Indigenous leaders have been saying since the beginning of the kind of formal constitutional recognition process, whether you take it as 1999 with the kind of failed recognition provisions or line in the preamble at the Republic referendum, whether you take it as John Howard and his kind of last minute announcement in 2007 that he would run a referendum in his first 100 days to recognise Aboriginal and Torres Strait Islander people, or whether you take it as Gillard in 2011, we've had this very lengthy period of contemplating constitutional recognition of Indigenous peoples in this country. And they've consistently held the position that the reform must be substantive and it must be structural. And so there was at Uluru a wholesale rejection of symbolism, that symbolism is not needed, that the reform would only be accepted if it came with really substantive reforms. And look, that's really consistent with Article 3, of course, of the UN Declaration on the Rights of Indigenous Peoples. So the Indigenous peoples have the right to self-determination, and by virtue of that right, they freely determine their political status and freely pursue their economic and social cultural development. But in addition, as I've said before, the UN Declaration provides guidance towards the back end of the declaration, where it states that states should provide the recognition and observance and enforcement of Indigenous rights via way of treaties, agreements, constructive arrangements, for example. So I suppose the point I'm making here is that there has been a bit of tension between Indigenous peoples and the state until the Uluru Statement, that symbolism is not the kind of recognition that people seek in the Constitution, but rather the form of recognition in the Constitution must be something that empowers people, that is constructive and tactile in their daily lives, as opposed to something like a plaque that merely recognises that we were here. And I think that was very much influenced by the declaration that demonstrates the many, many ways in which the state can implement self-determination. And of course, that experience in the UN system by Indigenous peoples themselves has enabled us to see the many ways in which states, liberal democratic states across the world, recognise Indigenous peoples' political rights and allows them to participate in the democratic framework of the state and the activities of the state, both at a parliamentary level and an executive level. Of course, Principle 3 of the guiding principles simply states that it should advance any proposal that goes forward to the referendum has to advance self-determination and the standards that are established under the UN Declaration on the Rights of Indigenous Peoples. And I think that's a pretty standard provision. I'll come back to that at the end, which should be in about 3 minutes, I think, to keep the time, where self-determination is kind of being reinterpreted, I think, at a Commonwealth level, in terms of what it does mean. But Principle 3 is kind of speaks for itself. Principle 4, which I stated, was, it recognizes the status and rights of First Nations peoples. Again, that assessment principle is fully imbued by the Declaration, and it's also underpinned by our own people's statements for many decades, the Barunga Statement, the ASIC Social Justice Package that wasn't implemented. And it's fundamentally about the respect and promotion of the inherent rights of Indigenous peoples, which I think, as the preamble to the Declaration says, derives from their political and economic and social structures, and from their cultures, spiritual traditions, histories and philosophies, and especially their rights to land, territories and resources. Principle 5 is interesting, it's called Tells the Truth of History. And the dialogues raise the issue of, they didn't really use the language of truth telling, they used the language of history. So it was a pretty powerful process to participate in, as different regions spoke to the different stories in Australian history of their people, including the frontier wars, the frontier massacres, and many the protection era, the many different periods of Australian history and how it applied to Aboriginal people. And look, truth telling is not a new thing. It draws from multiple kind of previous iterations of Indigenous advocacy for recognition and reform, the Eva Valley Statement, the ATSIC report, etc. But the UN Declaration does enshrine the importance of truth telling, as does the UN General Assembly resolution on the basic principles on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law. And so there was a lot of discussion about some of those Human Rights Council resolutions, such as the resolution on the right to truth in 2009, and a vast array, as everybody knows. Transitional justice is very deeply embedded in the work of the United Nations. And so a lot of that imbued, I suppose, the principles that will be used for the assessment of any proposal that goes to a referendum. Although I've written recently in the Monthly that I feel like post Uluru, what the dialogue said about truth telling has been lost, because all of that transitional justice theory and practitioners have kind of come over the top with their kind of little formulaic framework of, to get to treaty, you must need truth. To get to justice, you must need truth. And here's what that might look like in a commission of inquiry, and, go and tell your stories for 10 years and then nothing ever comes from the recommendations. I worry about, as I talk in the Monthly, about the ways in which what was a very organic and unique Australian conversation has been hijacked by that kind of international transitional justice discourse. And I'll try and hurry this up. I won't go through all the principles. I'll give Sydney Law my paper, but Principle 8 looks at the mechanisms that Indigenous peoples need for agreement making, as set out in the Declaration. And probably Principle 9 is very key, because it's about how you garner the support of First Nations peoples. And I think the really key thing about the dialogue was that it was actually the first time that we'd gone out to communities and asked them what they thought constitutional recognition was. So we were retrofitting Indigenous input, really. And I don't mean Indigenous elites, I mean the Indigenous community, their input into what constitutional recognition was or is, we retrofit that like 7 years after the fact, and that's not really the most appropriate way to run these kinds of processes. And so that's why the regional dialogues are so important, because that's what we did. We got that support by allowing people to make a decision about the options on the table. And that failure to consult that is so common in Australian politics, you know, really fed the outcome of the Uluru Statement, which was this kind of voice to Parliament, which again is a kind of common mechanism around the world that allows states to elicit that opinion from First Nations peoples. So I noticed there's 8 here in Queensland, 9:33, and I know we have to stop at 9:40. So Sheila, I'll just make a couple of quick comments and then get you to facilitate any questions if anybody has any. But I just wanted to conclude by kind of reflecting on the state of play in terms of Australia. I mean, I don't think I have to tell many human rights lawyers that Australia is regarded pretty poorly internationally in the context of Indigenous people's rights. And most recent external assessments of Australia in the DRIP, from you know, the UPR to the UN Special Rapporteur on Indigenous people's rights, really reinforces a pretty deeply concerning situation. And it's one that the Uluru Statement from the Heart, the people who wrote it and contributed to it, called structural powerlessness. And so, and I think that's why the sequencing of the Uluru Statement from the Heart is so critical, with a constitutionally enshrined voice being considered more important than a treaty, which comes second to that. I won't talk about ethics. I'll just make a few comments though about the state of play. So the Uluru Statement and the Voice to Parliament is one that's aimed at providing structural support required for First Nations voices to be heard. And I think one of the problems we have at a Commonwealth level is the Commonwealth or the federal government stepping away from its post-1967 responsibilities. This has been something that has been going on since 2014, but it's very acute in the Indigenous affairs space. And as the former advisor to many ministers, but also the former head of the Department of Indigenous Affairs, Mike Dillon, has argued, it's a pretty serious stepping back of its 67 responsibilities, where the Commonwealth now says, and I know they say this in a lot of areas, that they are just the ATM and they have no primary responsibility in the state anymore. They don't have the primary responsibility. They're a stakeholder similar to state governments and territories. And he makes the point, what is the public interest here? Australia's continued failure to tackle deep-seated Indigenous disadvantage diminishes us all, and that the federal government's ongoing retreat from policy responsibility is driven by short-term politics and doesn't align with the expectations of the Australian people when they voted overwhelmingly in 1967 to give the Commonwealth the power to legislate in relation to Aboriginal people. More insidiously, he says the pretense and self-deception that's involved in reassuring ourselves that we are doing all that is possible and that somehow the issues are intractable and thus insoluble undercut the very integrity of our democratic culture. This is not a win for the public interest. And kind of running alongside this kind of Commonwealth walking away from those obligations and responsibilities and effectively sabotage closing the gap 5 years into a 25-year kind of process, is the kind of way in which they've worked to undermine the Uluru Statement from the Heart, and in particular the fundamental kind of ask of Indigenous peoples to have an active role in the work of the National Parliament, but more importantly, to bring accountability to bear on the federal executive that currently has really no accountability for the decisions that it makes. And we know that the Australian National Audit Office has done a number of reports on these decisions that violation or continually violate the Commonwealth guidelines with respect to the managing of taxpayer funding, in particular billions of dollars of taxpayer funding. And it's really critical then, as we move to what we hope will be the implementation of the Uluru Statement from the heart, for the Commonwealth to step up to its obligations under the post-1967. But finally, and I'll stop here, Taylor, the way in which they've gone to Geneva since 2014 and delivered these speeches in the Human Rights Council and in New York, you know, recalibrating what self-determination means and what the government does to implement the DRIP and rights under the declaration has been, again, as Mike Dillon says, in plain sight and deeply concerning, and involves the chipping away of the collective nature of Indigenous people's rights, and speaks unusually to policy frameworks that no other country speaks to. So while other countries are talking about autonomy, autonomous arrangements and treaties, the Commonwealth government is talking about Indigenous procurement policies and entrepreneurial policies and Indigenous business, and they never speak about human rights anymore. It's all to do with those policies, which is their policy framework, the trickle-down approach. If we get as many Aboriginal and Torres Strait Islander people into business, then that will trickle down. The benefits of that will trickle down to communities, and eventually communities will be able to uplift themselves. But I make that point as a UN MRIP expert who's been watching this development for some time now, and hopefully with the implementation of the first tranche of the Uluru Statement from the Heart, we will see an arresting of that, which I think has been really detrimental in many aspects of Indigenous policy. But I'll stop there, Teela, because I know there's like 1 minute, so you might want to get in one question.
Thanks, Professor Davis. You
Feel
are
like
as inspiring as ever. I love waking up in the day, looking at you and hearing you. We have a few questions coming in now. The first is from Justine Nolan, and this is a question for you. Australia has a long reluctance about embracing international law at a domestic level. So is it helpful or not to situate structural change in PIL to get progress in Australia? Can the legal traditions advance socio-political stalemates? Are they quite divorced from it?
Thanks, Justine. I did text her and go, thanks for that question this early in the morning. Sorry, I'm just reading the question again. It says long reluctance when present. Yeah, no, I mean, Justine, I agree with you. I mean, I think given Australia's rights reluctance and the difficulty of prosecuting any argument publicly utilising international human rights law or public international law, no, I mean, I guess it's not helpful, if I could say that. It's one frustrating thing about living in the in Australia, the fact that you can't really draw on international human rights law as a respected kind of, some people might disagree with me saying this, but that's okay. You can email me offline, but as a kind of useful, benchmark for something like Indigenous rights, because it does get dismissed, right, as, Justine, just elites blathering on from the ivory tower, blah, blah, blah. And so one of the things, Justine, we did do, so one, so this non-discrimination clause that came out of the expert panel's work, all of the expert panel's work was very much rooted in the Declaration and the international human rights law. And I think the shift with the Referendum Council's work was to think, I guess, more carefully about Australia, the language and Australia's political temperament around human rights. And we did adopt a much more Australian public law discourse, that enabled people to understand what we were trying to say in the context of, our public law traditions and, Westminster traditions or Washminster traditions, to make sure that the language and the things that we said aligned much more with Australian public law than public international law. And I'll just stop there, Justine, and I'll answer the rest of your question on Instagram.
Megan, I have a question, and it's kind of about all the different layers of the international, the domestic level, and I kind of, given that your design of the dialogues was so sophisticated, as you said, from the grassroots level up, I was wondering if you could give the attendees some insight into how knowledgeable our elders and old people were in distilling those different layers of the legal system, and how, again, what you've explained about the Federation trying to chip away at self-determination and how people advocated in those spaces. Some anecdotal examples maybe.
Yeah, so you're right. I mean, one of the things we did was we decided not post-expert panel, but we reflected on the work that had happened there. And we realized if we were going to do a proper process, we needed to make sure that decision-making was imbued with our cultural authority. So we made sure that whoever participated in the dialogue, 60% of the invitations had to be our elders, our cultural authority, our traditional owners. It's we are a collective, but we are a gerontocracy. So our decision-making is done by elders. And so it did transform, Taylor, the outcome, I think, of the meeting, because some of the younger generation, tend to get taken away by different agendas that, when you're sitting there weighing up different constitutional options, so the younger kind of people coming through, leaders coming through, are more likely to be saying, abolish the state, don't work with the state, this will cede our sovereignty, and then 5 years down the track, you've got nothing because, it's 0 or 100, right? And they're able to say that, but not actually provide, well, what does that look like? What are you talking about? Are you talking about a separate state? Are you talking about autonomous region? And how are you going to provide, or at least manufacture, the political imperative that's required to make things happen in a political system? And I think a lot of our old people had been through this for many, many decades, from before 1967, they participated in 67 and after 67. That is to say, our people since the early 1800s have constantly said, we want to be actively involved in decision-making about us at a federal level, and find mechanisms that enable us to have that voice. And so I thought, Taylor, both with their invocation of how they practice law now, Aboriginal law, I mean, and the manifestations of Aboriginal law today in an urban setting, and the practice of Aboriginal law in kind of regional and remote areas where we went, such as the centre, where they invoked Jukupa as being their key law. They understood that that was our law, and that the comparator law in Australia was the Constitution. Like, that is how, they would say, that is how, white fellas make decisions. But that's how, if they want something really seriously done that stops the government from doing something or makes the government do something, they put it in the big law. Yeah, they don't just put it in legislation, they put it in the big law. And so those conversations were had about, the different kinds of proposals that were on the table. And as you said, Taylor, I think, you and I often spoke about this, about the wisdom of their decision making. 3 days of constitutional deliberations, and then you get to the end and they come up with this kind of elegant solution that no other constitutional lawyer had conceived of prior to the dialogue. And I think that speaks to not just that deliberative process, but how it's a perfect example of people designing their own future, right? And that you can rely on people to know what the solutions might be to their own problems. because they live it every day and they lead these communities every day. And it was quite an extraordinary, I think, not just an extraordinary Australian innovation, but I do think the men and women of the dialogues, particularly our old people, Tila, just the generosity that they exercise, given all that has come before, it was the most extraordinary outcome. You know, clever, smart, consistent with Australia's political and legal traditions. And yeah, it was just an incredible experience. And I hope a lot of Australians, Tila, get to understand and learn about in the coming months.
Yeah, and with that said, we are all so much richer to have you on our side, Professor Davis. Thank you for your keynote. Thank you for your time. And I'm going to hand it over now to the facilitators.
Wonderful. Thank you, Tila. And thank you, Professor Davis, for your fantastic presentation. Please join me in thanking Professor Davis. Hopefully she can hear us.